ನಿಮ್ಮ ಕೆಲಸ ಅದನ್ನ ನೀವು ಸರಿಯಾಗಿ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಯು ಆರ್ ಕ್ಯಾರಿಂಗ್ ಔಟ್ ಯುವರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟೀಸ್ ವೆರಿ ವೆಲ್.
ರಮಾಕಾಂತ್ ಸರ್ ಜಾಯ್ನ್ ಆದ್ರು, ಜಡ್ಜ್ ಫ್ರಮ್ ಸಮಷ್ಟಿಪುರ.
Namaste Mahadeva sir. I'm not able to understand Kannada at all, so I would be obliged to
Okay, ma'am. Okay, ma'am.
speak
Okay,
in
ma'am.
English.
Like,
Because
yes,
since
ma'am.
I'm
No,
not-
madam.
Yeah, sorry.
Okay,
No, madam,
ma'am.
they are praising me. I told that it is not necessary. It is a team like that. With sir as mentioning something about me, I told that it is not the
I would
platform
like
and
to
answer.
listen to it, sir.
And madam, like just we were acknowledging the efforts which are undertaken by Mahadevaya Kardalli sir in organizing
Yes,
this
sir.
particular
Yes, sir. That's what.
online special
Yes,
lecture series. It's not an appreciation or it's not a praise. It's a factual situation which needs to be acknowledged in this platform also. So we were telling about that. And whenever we speak in Kannada, like I'll also translate it in English, ma'am, and I'm extremely sorry. Basically, what we thought is most of them are well-known, well-versed in Kannada. That is the reason like some conversation happened in Kannada. And henceforth, like any like conversation which takes place, I'll also translate it in English, ma'am. Ramakant sir ಅವರಿಗೂ ನಮಸ್ತೆ.
ನಮಸ್ಕಾರ.
ಇವತ್ತು ವೀಕೆಂಡ್ ಬೇರೆ ಇರೋದ್ರಿಂದ ಹಾಗೂ ಸಂಡೇ ಆಗಿರೋದ್ರಿಂದ ಬಹಳ ನಮ್ಮ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ನಲ್ಲಿ ಒಂಚೂರು ಉತ್ಸಾಹ ಕಡಿಮೆ ಆಗಿದೆ. ರೆಗ್ಯುಲರ್ ಆಗಿ ಲಾಗಿನ್ ಆಗ್ತಕ್ಕಂಥವ್ರು ಕೆಲವರು ತಮ್ಮ ವೈಯಕ್ತಿಕ ಕಾರಣಗಳಿಗಾಗಿ ಏನೋ ಒಂದು ಅದರಿಂದಾಗಿ ಇವತ್ತು ಸ್ವಲ್ಪ ಸ್ಟ್ರೆಂತ್ ಕಡಿಮೆ ಇದೆ. ವಿಧಿ ಕನ್ಸಲ್ಟೆನ್ಸಿ ಸರ್ವಿಸಸ್ ಇಲ್ಲಿಂದ ಲಾಗಿನ್ ಆದವರು ನಮ್ಮ ಮೊದಲನೇ ಸೀರೀಸ್ ಇಂದ ಇಲ್ಲಿ ತನಕನೂ ಅವರು ನಮ್ಮೊಟ್ಟಿಗೆ ಯಾವಾಗ್ಲೂ ಈ ಆನ್ಲೈನ್ ಲೆಕ್ಚರ್ ಸೀರೀಸ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ. ಅವರಿಗೂ ಒಂದು ಧನ್ಯವಾದ. ಮಾದೇವಯ್ಯ ಸರ್ 6:40 ಆಯ್ತು. ನೀವು ಹೇಗೆ ಹೇಳ್ತೀರಿ ಹಾಗೆ ಇನ್ನೊಂದ್ 2 ನಿಮಿಷ ವೆಯ್ಟ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದ್ರೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. ನನ್ನ ಹೆಸರು ಸುಬ್ರಹ್ಮಣ್ಯ ಅಂತ, ಅಡ್ವೊಕೇಟ್, ಬೆಂಗಳೂರಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನನಗೆ ಕೋದಂಡ ರಾಮನ್ ಸರ್ ಲಿಂಕ್ ಕಳಿಸಿದ್ರು, IRS ಕೋದಂಡ ರಾಮನ್ ಸರ್.
ಹೌದಾ ಸರ್? ಅಂದ್ರೆ ನಾವು ಅದನ್ನ ಗಮನಿಸ್ತಾ ಇದ್ವಿ ಸರ್, ಈ ವಿಧಿ ಕನ್ಸಲ್ಟೆನ್ಸಿ ಸರ್ವಿಸ್ ಅಂತ. ತಮ್ಮ ಹೆಸರು ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಸುಬ್ರಹ್ಮಣ್ಯ ಸರ್.
ನಾನು ಅದು ಆಕ್ಚುಲಿ ನನ್ನ ಕನ್ಸಲ್ಟೆನ್ಸಿ ಫರ್ಮ್ ಹೆಸರು ಇಟ್ಟಿದ್ದೀನಿ. ಸೊ ಸಾರಿ, ಐ ವಿಲ್ ಚೇಂಜ್ ಇಟ್, ರೀನೇಮ್.
ಇರ್ಲಿ ಸರ್. ಅಲ್ಲ ಅಂದ್ರೆ ನಮಗೆ ಏನಂದ್ರೆ ಯಾರೋ ಆಸಕ್ತಿ ಇದ್ದಾರೆ ಇದ್ರ ಬಗ್ಗೆ ತಿಳ್ಕೊಂಡ್ಲಿಕ್ಕೆ, ಇದ್ರಲ್ಲಿ ಲಾಗಿನ್ ಆಗ್ತಿದ್ದಾರೆ ಅನ್ನುವಂತ ಒಂದು ಕುತೂಹಲ ನಮ್ಗೆ.
ಹೌದು ಹೌದು ಸರ್, ಹೌದು ಸರ್.
ನಾವು ಎಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್
ತೋರಿಸ್ಬಿಡ್ತೀನಿ, ಯಾಕೆಂದ್ರೆ ಅದು ಕೂಡ ಇಂಪಾರ್ಟೆಂಟ್. ನಮಸ್ಕಾರ ಸರ್, ನಮಸ್ಕಾರ. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. ನಮ್ಮ ನಿಗದಿತ ಸಮಯದಂತೆ ನಾವ್ ಇಲ್ಲಿ ತನಕ ಪಾಲಿಸ್ಕೊಂಡ್ ಬಂದಿರತಕ್ಕಂತ ಒಂದು ರೂಲ್ ಏನಂತ ಹೇಳಿದ್ರೆ, ಎಷ್ಟೇ ಪ್ರೇಕ್ಷಕರಿರ್ಲಿ, ಎಷ್ಟೇ ಲಾಗಿನ್ ಆಗಿರ್ಲಿ, ನಿಗದಿತ ಸಮಯಕ್ಕೆ ನಾವು ಕಾರ್ಯಕ್ರಮನ ಶುರು ಮಾಡಿ ನಿಗದಿತ ಸಮಯಕ್ಕೆ ಅದನ್ನ ಮುಗಿಸುವಂತ ಒಂದು ಪ್ರಕ್ರಿಯೆನ ನಾವು ಇಲ್ಲಿ ತನಕ ಪಾಲಿಸ್ಕೊಂಡ್ ಬಂದಿದ್ದೇವೆ. ಸೊ we always start the program on time and we try to also keep the schedule throughout the program. So Madhevaya sir, like with your permission, like we will start.
Yes sir, start sir, start.
So as already said that this Vignaneshwara Pratisthana Trust Marturu, it has taken a serious efforts in organizing this special lecture series in association with Central University of Karnataka, Department of Law, Kalburgi University and Karnataka State Law University, Hubli. So we have conducted the special lectures, and today's lecture is a 4th lecture in the series. And these lectures are being organized in commemoration of 95th birth anniversary of Shri Justice Dr. M. Ramajoish sir. And his contribution is immense. At the same time, like we also want to know the contributions of Vignaneshwara and his teachings and his like discourse. And the topics are so relevant to the contemporary world also. And we want to give enlightened knowledge to the participants who take part in this particular program with regard to ancient Indian jurisprudence. So today we have with us our president of today's function, Professor Dr. T.R. Subramanya sir, Dean CMR University, School of Legal Studies, as well as our former Vice Chancellor, Karnataka State Law University, and guest of honor, Dr. Ramakant Sharma sir, Principal Judge, Family Court, Samastipura, Bihar. And our resource person for today is
Srimati Sneha Bipin Sapre, Madam, Administrator, BORI Infosys Academic Development Program, and Krishna Kumar Shekhar Sharma, Mr. Tapan, as well as Shri Amit Kumar Deshpande sir is not in a position to log in today. And Madevaya Kardali sir, like as usual, he's a backbone of this particular program. So I wish that all of us will definitely get enlightened to listening to today's lecture. So with this, I now invite Maheshwari, Dr. Maheshwari Iremat Madam, Principal, SSL Law College, Kalburgi, to formally welcome and introduce today's president as well as the resource person of the session.
Thank you, sir.
Sorry, madam.
So, good evening to everyone. It gives me immense pleasure to warmly welcome all the distinguished dignitaries, principals, faculty members, scholars, students, and participants who joined us for the Justice Dr. M. Ramajoy's Memorial 6th Online Lecture Series 2026. As you all know that the topic of today's virtual lecture is very important and it is relevant to contemporary word, that is legacy of ancient Bharatiya jurisprudence, timeless tools for speedy justice in digital era. So as already said by Girish sir, today resource person is Srimati Sneha Bipre Madam. So it is my privilege to introduce our distinguished guest of today's virtual program. So firstly, I am honored to introduce the president of today's virtual program, Professor Dr. T.R. Subramaniam Sir, who is presently Dean, School of Legal Studies, CMR University, and Sir is an eminent legal academician with vast experience in legal education research and administration. Subramaniam Sir has previously served as a Vice Chancellor of Karnataka State Law University, Hubballi, and Sir has held several other academic positions at prestigious institutions, including Bangalore University and National Law University, Kolkata. Sir has also made significant contributions to legal research and publications, and Sir has also guided 14 PhD research scholars. Sir has served as a legal counselor to the Kingdom of Bahrain for 7 years continuously, bringing valuable international legal experience. We are indeed honored to have with us today. I extend a very hearty and cordial welcome to you, sir, and thank you for joining for this online program. Welcome you, sir. And today's guest speaker, the main resource person of today's program is Madam Sneha Bipin Sapre. Madam is an accomplished academician, Sanskrit scholar, and legal professional with extensive experience in the field of education, administration, and law. She holds many degrees and post-graduations in various subjects, along with a diploma in German language. She has been associated with the educational field since 1989. And Madam has held several important positions, including Headmistress, Vice Principal, Joint Registrar at Bhandarkar Research Oriental Institution, Pune. And she is an administrator of the BORI Infosys Academic Development Program. Madam has presented, delivered lectures, wrote many articles on topics such as Dharma Shastra and modern law, Bharatiya knowledge system, ancient Indian judicial and legal system, and at various conferences and various seminars, national and level international seminars. Madam has also designed online courses, including digital Sanskrit learning. It is an online courses which consist of digital Sanskrit learning level 1 and Dharma Shastra and modern legal system, which have reached a wide number of learners. And the guest of, so with this introduction, I extend a hearty welcome to you, Madam, for this virtual program.
Thank you very
And
much.
the guest of honor of today's program is Dr. Ramakant Sharma, who is presently Principal Judge, Family Court at Samastipur in Bihar State. Sir, before becoming the principal judge, Sir had also served a senior public prosecutor in Haryana state. Sir had doctorate in intellectual property rights and is also pursuing studies of Dharma Shastra. Sir, I extend a cordial welcome to this virtual program.
Thank you. Thank you very much.
Yes. I also welcome Sri Amit Kumar Deshpande, but due to some emergency, he could not log in. But I extend my hearty welcome to Amit Kumar Deshpande, Senior Advocate and Trustee of Vignaneshwara Pratisthana Trust. I also extend my heartfelt welcome to Sri Lakshmi Narayan Sir, who has served as a Deputy Commissioner at our Gulbarga city, and Sir has also served as a Additional Secretary. Sir, I extend a hearty welcome to you, sir. In the same way, I extend a hearty welcome to Sri Madhavaya Kardalli, sir. As said by Girish, sir, he is the backbone of all this development. Sir, I extend a hearty welcome to you. I also extend all the participants, advocates who have joined this virtual program. So, lastly, I extend my sincere and respectful welcome to one and all. Thank you.
Thank you for such a wonderful welcome and introduction of the speaker and president and guest of honor, Maheshwari ma'am. On behalf of organizer, I extend a cordial welcome to you also, Dr. Maheshwari Hiremat, Principal SSL Law College, Kalburgi. And before moving towards the session, I also acknowledge the presence of the Principal of Vivekananda Law College, Puttur, Dr. Akshata AP, as well as Professor Basavaraj Kubakaddi, Dean Faculty of Law, Central Law University. I acknowledge their presence in this particular program. So with this, now it's a time to listen from our resource person. So may I now take an opportunity to invite our speaker of today's session, Srimati Sneha Bipin Sapre Madam, Administrator, BORI, Infosys Academic Development Program. And Madam will be speaking on the topic, Legacy of Ancient Bharatiya Jurisprudence, Timeless Tools for Speedy Justice in Digital Era. Madam, over to you.
Thank you so much, sir. Thank you so much. Namaste and good evening, everyone. Before I begin, I pay my respectful homage to Justice Ramajoyce, who is leading us in the path of study of this ancient Indian jurisprudence. Namaste and good evening, Professor Dr. Subramaniam, Dean, CMR University, Honorable Principal Judge, Family Court, Samastipur, Bihar, Dr. Ramakant Sharma, Dr. Krishna Sharma, Dr. Girish KC, Advocate Amit Kumar Deshpande, who is not present here, but I would really like to wish him for today's evening, and Sri Mahadevaya Kardalli, who has always been helping and taking so much efforts to take this subject ahead. And along with this, I welcome all the respected audience who is present here online today. So my lecture shall run in 3 steps today. First is ancient Indian jurisprudence, the steps taken by the judiciary for speedy trials. Then in the second phase, I will speak a little about the current situation where the situation by the justice is delayed. And the third step, I will compare the ancient and modern jurisprudence and the problems for delay in justice. Kindly allow me to read my lecture today because it's very difficult for me to cover up such a huge topic in a short span of time. So I've tried my best to gather maximum important points and present before you today.
Yes,
so all of us know that justice hurried, justice worried, and justice delayed is always justice denied. Judicial pendency has been a matter of concern since ancient times, and speedy trials and quick relief, or rather, I can say that justice without delay, was always promoted by the then lawmakers as well as the modern lawmakers. Now, the famous play by William Shakespeare, Hamlet, all of you must be knowing, where the Hamlet lists his heavy burdens in the life of a man, and those are he has given 3 important steps where the situations which really put a burden on human life. The first is oppressor's wrong. The second is proud man's contemporary. Third is the pangs of despised love. And lastly, the most important, law's delay. So he has also taken a cognizance of delay in law, how it hurts a person in the society. And he enumerates the principal evil of a human life. I always feel that literature is a mirror of the society. It gives you the really true picture, whatever happens in the society at that particular span of time. Bharatratna P.V. Kane says that before 1873, delay in decision of cause was a crying evil. Now, while administering the timely justice in ancient India, a lot of care was taken by the Smritikaras and the then lawmakers. Now, I will use the word lawmakers to for the Shruti and Smritikaras, that everyone must be knowing that those are the persons or the people who have composed the law for us. Now, first, before I begin, I will quickly tell you roughly about the judicial system at that time. Now, the ancient law deals separately with substantive and procedural laws as we see today. The substantive law was called as Vyavahara Matruka and procedural law was called as Vyavahara Pada. Now, this judicial process or the legal system had four stages, as we also have now. The four stages are called as four legs, that is Chatushpada. First pada is Bhasha Pada, Uttarapada, Kriyapada, and Siddhi. So Bhashapada is filing of plaint. Uttarapada is filing of written statement or the say from the defendants. Kriyapada is evidence, and Siddhi is judgment, the final stage. So these were the these were the four stages in which the procedure of law used to happen. Now, in this ancient judicial system, the king was considered to be the fountainhead of justice. His position was just like a Chief Justice of India or as the apex court. Morally and officially, he was presumed to be responsible for the dispense of justice and control of crime in his state. And his first and foremost moral duty was to see the welfare of the state. The welfare of the state was byproduct of his administrative skills. If we look at the separation of powers, the king was taking care of executive and judiciary, and legislature was taken care by the Dharma Sutra and Smritikaras, that is the lawmakers of that time. The scriptures, thus, in the position, according to the scriptures, the position of the king was really pivotal. Katyayana. So all of us have understood by now that if I have to talk on king and his administrative and legal position, it will really take a lot of time. But in short, I can say he was a fountainhead of justice, and he was a last authority in India. Now, Katyayana, he is one of the most important and a famous Smritikara. And Shukra, the author of Shukraniti, have warned the king that न कालहरणं कार्यं राज्ञा साधन दर्शने महान दोषो भवेत् कालात् धर्म व्यापत्ति लक्षणम, meaning the king ought not to waste time in dispensing justice, and to do so is a very serious flaw that leads to the dharma vyapatti. Dharma vyapatti, the meaning of dharma vyapatti is death of justice. So according to the Dharma Sutrakaras or the lawmakers, then they said that if you delay the justice, you are causing the death of justice. So deciding the cases lately is a tantamount, and it's a denial of justice, they used to say. Kautilya also says that the king should not cause petitioner or the litigants to wait long at the doors of the king and waiting for the justice. The king must make himself accessible. Now, all of us, we see the accessibility to the justice is a very important, a crucial point. Otherwise, the king emerges in dissatisfaction among the subjects and makes himself a prey to the foes. And hence, accessibility to the justice and speedy trial was a focal point of the then lawmakers. There is a very famous story of King Muruga in Ramayana. The king Muruga became Shamayan for a very long time by a curse given by two litigants who had dispute of ownership of a cow, they were waiting at the doors of the justice for a very long time, and since they could not meet the king, the justice was completely denied, and hence they cursed the king, and he suffered for that. So literature, see, forget, I mean, whatever the literature or the story says, is story apart. But we can understand even in the period of Ramayana, people were trying that the justice should be accessible and justice should be given in time. So delay will definitely cause the death of justice. Now, delay in justice always, it gives a cause of unrest in the society then and even now. It was considered to be the administration of justice was a personal concern of the king. Now let us see how the lawmakers tried to avoid the delay in the procedure. I'm sorry to say, but those days there was no, system of like an advocates. Advocates were not there, lawyers were not there. Of course, they were there. The concept was there, but the scope was very limited. So now let's see how the system tried to avoid the injustice caused by delaying the process. As I told you initially, the four stages of law. So in the lawsuits, when the petitioner files his petition, this contains, in the first stage we call as a bhasha pada. So in this stage, when this petitioner he files his petition, the contents were reduced into writing by a scribe in the court, and the defendant was summoned after the scribe writes it down in the court. And when the defendant is summoned, he appears before the court. Once the defendant appears, the petition draft was always read over to the petitioner in front of the defendant or the respondent, and then the draft was reduced second time into writing. Initially, front of the petitioner. Second time it was written once the defendant appears and it is read over to all of them. Everyone listens to that. And second time it was reduced into writing, and the second time written draft was considered to be final. So once this second draft was finalized, then no amendment was allowed to be carried out. So this was, a very very important stage, that they were allowed adjournment, the amendment in the petition once it is reduced into writing in front of the petitioner as well as the respondent. Thus, I can say the no order 6 rule 17 of CPC here. So to amend the pleadings, petitions or the WS, it doesn't occur there. So also the order 7 rule 11 of CPC to reject the plaint in the very beginning of the lawsuit. So these two steps were, cut down at there and there itself. So there was no amendment and no 711. So and sometimes we come across that very cleverly some advocates, I will not say that they are doing something wrong, they are definitely doing it in the interest of justice, but sometimes lawyers also take very clever steps, just making some amendments or taking 711 or such things, but such things were always, they were nipped in the bud. Now we'll come to the limitation of filing the written statement. The limitation for filing the written statement was very less. They were expected to submit their written statements as soon as possible, sometimes even in 3 days, says the Mitakshara. Now, once the defendant files his written statement, the petitioner was supposed to support his case by giving the evidence immediately, failing which it was declared that he was defeated. This is because the petitioner was presumed to be having merits and strength in his case. And since the petitioner knows his case well, they felt that there is no need to wait. Come and immediately give your evidence. But on the other hand, the defendant was allowed adjournment. And this is because he was the one who was dragged to the court by the plaintiff, and which may be extended to 3 to 7 days. So if he doesn't do so, then he was fined ranging from 3 to 12 panas. If the respondent fails to file his written statement within a fortnight, then sometimes they might consider giving them sometimes looking at the urgencies also. But if he doesn't file it within the fortnight by drawing, then the adverse inference was always drawn, and the petitioner's claim would have been recovered from respondent's property. Now, it was a case of civil suits, but regarding the sahasa or the criminal matters, the heinous criminal offenses like murder, offenses relating to the dignity of women and female slaves, so also the criminal offenses like theft, abuse, assault, charges of grave sins. No time was given to the accused, and he had to give his defense at once. In the other cases other than these criminal cases, the court had discretionary powers to allow the adjournment. This is what Narada says in his Narada Smriti. In case of some complicated suit or debt recovery, Pitamaha is one of the Smriti makers, he says that the memory of the human beings may be very weak. So, in order to avoid the adverse impact of evidences, the adjournments may be allowed in the matters of deposits, sealed deposits, gifts, partnerships, and partition suits. So he always feels that the memory of the human being, it may be very short or the limited. So where the matter of memory is concerned, they should give priority, and adjournment should be given to the documentary evidences where it lies for a longer time. Then I guess that this would be because of all the cases of documentary evidences. And they felt that they're always stronger than that of the eye evidences or the eyewitnesses. Now, as all of us know that these Smritis, they have this jurisprudence, I can say they have the very long history spanning over 2000 years. It's a written history, it's a proof with us. So it is spanning over 2000 years. The law evolved very gradually. And as we see, we have the codified laws, but those days the laws were not codified. Everyone had their own smritis or their own writings. We can say we have almost 100 smritis with us who opine differently as per their own thinkings. And as we all know, that there was no connectivity as we have today. We are speaking online and offline everywhere. But those days, people were staying at different area, zero communication. But in spite of that, most these people you will find that they are on the same page on most of them matters. But now, pertaining to the trials they always felt that the trials pertaining to women, children, always there should be speedy trials and there should not be prolonged procedure or delay in giving justice to them. Even now we see that we are trying to have, the fast track courts to give justice to the women and to the children as fast as possible. Now, Bruhaspati seems considering the petitions as well and in a different way. He says that the time may be permitted to the petitioners and see, initially we have seen that they permitted adjournments to the respondents, but Bruhaspati feels that the time should be given to the petitioners as well, because sometimes the petitioners may be shy, they may not be bold enough to put forth their case, or sometimes they are immature. But that should not be the cause that they should not get the justice. So, in such cases, Smritikara Bruhaspati feels that they must be given time to plead their case or to make their stand and to get the justice. He says that Abhiyokta apragalbhatvat vaktum notsahate yadi tasya kalaha pradatavyah karya shaktya nirupataha. So this is what is agreed by Smriti Chandrika and Apararka Katyayana as well as. Now Katyayana and Apararka, they also have said that the king or the judge must try to understand the grievance of the matters and then they have the discretion to give adjournment. A period of 1 month, 3 months, 5 days, 7 days may be given in the interest of justice, as we say in the common language. So they had, according to them, they had the discretionary power looking at the condition, looking at the situation. They always used to give adjournments to give interest to the justice. It seems to have been more considerate regarding the matters of debt recovery. Debt recovery is again, I found in some of the texts that, it was a very important point which they always kept emphasizing on. Now, while giving adjournments, some points were given by the Smrtikaras. Now they say to see whether the defendant is lunatic or suffering from diseases. In such cases, they might allow the adjournment. Whether the witness is abroad is another matter of concern. If the witness is abroad, then they would give the adjournments. Then they also speak about daiva, which we can say the act of God, or if the king prevents him from giving his defense. So there are two things for the defendant. If there is something untoward situation happens, and there is an act of God, or if the king himself prevents him from giving his defense. And in such cases, the time may be given that to the defendants to support his defense, but then once again the adjournments they always focused on the frequent adjournments and duration for a longer time. In such cases, the Smritikaras never wanted to see any death of justice for want of Kalaharana for sure. So their focal point was always whether the defendant is asking for frequent adjournments or the duration for the adjournment is always going for a longer time. So in those cases, they had given the discretionary power to the king to look into the matter and do the justice looking at the facts of the cases. Now, the ancient Indian jurisprudence was blend of sanction and sanctity. Now, we have seen adjournment, which was really a matter of concern, which all of us feel that because of which, the justice is delayed or the procedure is delayed. But that is not the only factor which impacts on the delivery of justice. There are some more other factors as well, which we have more in the modern times as compared to the ancient time. And then sometimes the judiciary also takes some measures in order to expedite the matters, like the alternative dispute resolution system. The ancient Indian jurisprudence was also, they had also sanction and sanctity, as I said. They focused more on achara. Achara is a good conduct. So initially they used to see that the conduct of human being, there should be truthfulness and there should be loyalty and they should be behaving in a most the moral way. That behavior should be very much moral, so that unnecessary pendency on the judiciary for fighting and going into the litigation would be less as compared to the modern scenario. Now, the outer there and three stages. When I forgot, I'm sorry, but let me please explain this. There were this Dharma Shastra, that is the jurisprudence. It runs in three most important steps. First is called Achara, then is Vyavahara, and then is Prayashchitta. Now, see, Achara is a good conduct, Vyavahara is lawsuits, and Prayashchitta, it means expiations or the internal danda, antarik danda. See, if people they follow the moral behavior, lot of emphasis has been given on achara part by all the smritikaras and dharma sutrakaras at that time. So if the achar is not followed properly, then it gives birth to the litigations, that is vyavahara. And if the result of vyavahara is always a punishment. So the punishment was called as prayashchitta, or it is also called as expiation. It was called as antarik danda, which is a very a peculiar feature of all the ancient jurisprudence. Of course, they had provisions of danda. Please remember one thing: this danda and prayashchitta, there is a slight difference. There is a thin line between them. Danda is given, punishment is always given, and prayashchitta is taken. So prayashchitta is an you know, uh, internal danda, antarik danda, which the wrongdoer takes on his own in order to get rid of his wrong deed, or his papa, I can say. So after finishing that, as we have seen now, the focus was much more on the achara part, but they also had some alternative dispute resolution system within the local areas. And after this phase, even people can go to the king. Of course, it was not the compulsion on anyone, to follow this ADR, but most people used to do it at that time. This system is, I'll tell you, it is also in three parts: Kula, Shreni, and Puga. They were the local authorities which are similar to our tribunals today. The family disputes were resolved within the family itself by the senior members of the family. The disputes relating to the professions were resolved by the senior members of that particular community. Suppose if there is a litigation between some goldsmiths, then the senior most person in that particular community was the capable person, because he knows every small little detail of that particular profession. So he used to resolve the matter there and there itself. And lastly, the puga. Puga means the disputes which are arising in the towns or villages or so, where they were resolved by the chief of that particular town in the locality itself. All these parties had a right to prefer appeal to the king if they are not satisfied by the awards given by such tribunals. But the decisions of the king, which was given for in this appeal, was always considered to be final, and there was nothing about the king. Now coming to the challenges of this modern times. So I hope all of you have got a brief idea about the adjournments, the alternative dispute resolution system, and some things in the procedural law itself which can avoid the lengthy procedures or complicated procedures to make the things very simple and to give justice as as soon as possible to give relief to the litigants. Now, coming to the challenge of the modern times, there are several reasons who put burden on the judiciary. Delay in justice as compared to the olden days, and people have become more and more aware of their legal rights, and hence their approach to the courts is very positive. So this we can say it's a very a very positive sign that people do approach to the courts for getting relief. They're not suffering from injustices, but they approach the court to get the justice. But other than that, there are several reasons. This is the only positive side. But barring that, there are so many things which hamper the speedy trial and disposal of the cases. Now, I will very quickly read over these, these, what shall I say, the reasons for getting the delay in the justice. Everyone knows, but I will just quickly sum up a few of them. Now, the population explosion is one of the most important factor that impacts, and it makes as a result that the excessive number of pending cases in the court and excessive number of day-to-day filing of the new cases in the court. Then there is shortage of judges and the administrative staff. Delay in investigation process is always there. We all of us know that the complex nature of legal procedure that also hampers the system, and it leads to the delay of the justice. Then there is always inadequate court infrastructure and limited resources, which always hampers, it disturbs that it doesn't let the procedure to go in a faster way. Then there are challenges faced at the level of the witness. So we can say that the production of documents, filing of frivolous and unnecessary cases, which lead to the increase of the workload and burden of the courts. Then we know that the transfer of judges and the time used for repeated hearings. Sometimes it happens, but sometimes it doesn't happen. But most times, even I have experienced that the repeated hearing, it also takes the double time to to dispose the same case. Then now we see that there are many more new uh, problems occurring in the society, including the cyber crimes, which were not there in ancient times at all. So they are also putting a very heavy burden on our judicial system, and all this burden which is increased day by day, and inadequate number of judges and the infrastructure will definitely is not going in proportion, so that a speedy trial, speedy justice is always affected by that. And there is one more thing, that there is little less lack of awareness for using the ADR effectively by the people and the litigants. Now, finally, the most important, the lack of morality and truthfulness is the final thing, which not last but least, but the most important, which I thought of taking at the end, that people are, the morality and legality, there is always a conflict. Legality begins when morality ends. We have seen, there are several cases. If you just look at the 138 matters of check bouncing, people know that I have to give money to him. check is given, but still they are bounced. In Bombay, there are 7 courts for just for check bounce cases. So this is what people, their morality is certainly compromised, and that is always the crucial point. That morality and truthfulness is the only essential and the most important factor that does not, that is putting a heavy burden on judiciary. And then the judiciary always feel that the decision or the decision that happens in the court is always the last leg in the ladder, but it begins always with the morality and truthfulness which is lacking on the part of the litigants always. Now, the challenges as we see the faced by the olden society are extremely different as compared to the modern era. They had very less challenges. First of all, morality was very important, where people used to abide by moral conduct, and very less number of people who were cheaters or committing offenses in the society. So the pendency occurring out of this, this truthfulness was definitely less, but which is certainly increased in this modern times. Now, we can say the laws made at that time were suitable for those days. So those days the laws were made were definitely suitable for that particular society. But it is difficult, to compare or to equate with that system with current scenario, because we have seen the challenges faced by our society in this time are really different. So we cannot surely compare that particular system how it would be helpful in dealing with the problems of the modern system. But certainly only fact I could say that the truthfulness and morality, if people follow, then this is going to be forever, which will help the society to burden the judiciary and to raise the moral value system of our society. Now, I would strongly say that the problems are there forever. Problems were there at that time, and problems are going to be here now. Because the ancient judiciary, the Smritikaras, have very nicely said that there are 3 important um, dosha which are responsible for litigations. Those are, we call them Triyoni. Lobha, Krodha, and Moha. These are the 3 things which lead to destroy the morality of the people, and then they are called as Triyoni, that these are the main sources of offenses in the society. So, what fact which will remain forever? So, the problems were there, problems are now, problems are never going to get to an end at all. As long as society is there, problems are going to be there, but the remedies which are there will be definitely different in this time. So we cannot compare that system with today's system, but certainly if we focus more on truthfulness and morality, that is the only tool. If society decides, we decide to take, then litigations are definitely going to be mitigated. I'm sure for that. And you know, there is one famous Sanskrit shlok which I would quote, and I would explain in English to my best to for everyone to understand. The Subhashita says that yo asmat tatasya kupoyam iti ksharaha pibatyapah tyaktwambho maduram gangam mudham tam konu bodhayet. This Subhashitakar says that a person who wants to drink the water of the well which was constructed by his forefathers long ago, and he refuses to take the sweet water of the river Ganga. Who is able to convince that person? Really, no one. So, when new things, new best things are available, we must always, try to inculcate them, or to, take help of that particular thing in order to resolve the problems of the modern age. We have ancient, value system. We need to, stick to the value system and face the problems of the modern times with the modern weapons. This is what I always feel. And finally, the Sanskrit literature also, in one of the Subhashitas, they very nicely says that with the things which one has to do, they must do it there and then. And no person should delay his work under any circumstances. So this goes not only to the judiciary but everyone in our life. They say that adanasya pradhanasya kartavyasya cha karmanah kshipramakriyamanasya kalaha pibati tadrasam. Now, adana, pradana, if we have to give something, we have to take something, we have to do our duties. We must do it there and then without delay. Because if we don't do it within time, then the time itself destroys the beautiful fruits of our work. And here I would like to conclude my speech by saying thanks to Kadali sir and to everyone present here for listening to me. And I'm indeed thankful for giving me an opportunity to be here. Thank you very much, sir.
Thank you very much, ma'am, for such a wonderful discourse. Like you had vividly covered ancient Indian jurisprudence and thrown light on the present system, and you compared the ancient with that of a present system. And you also highlighted how there is two important concepts of sanction and sanctity, and this morality and truthfulness. That is the most important things to be kept in mind. And you also have covered about Achara, Vyavahara, Prayaschitta. It was a very nice lecture. So now, once again, on behalf of the organizers, I thank you, Madam Sneha Bipin Sapre, for delivering such a wonderful lecture. Now it's a time to listen from our guest of honor, Dr. Ramakant Sharma, sir, who is serving as Principal Judge, Family Court, Samastipur, Bihar. Sir, I request you to make your observations.
Namaskar to everyone. Indeed, today Madam has delivered a very important lecture, and she has encapsulated all the items in one lecture. It is indeed a great endeavor on the part of the university. I have great privilege to come here 2 years before. Justice Dr. M. Rama Joyce is indeed the Rishi in the present time, who has captured, who has envisioned, who has given his life to revive the ancient jurisprudence or ancient Indian vision or perspective, which is required. I would also like to add here that there is a great difference between the society structure which was prevalent during the Samriti period and today. Earlier, as we found in the study of Samriti, especially in the Yagvalkya Samriti, whose commentary is done by Gyaneshwara in Mitakshara, that state was not the discoverer of disputes. State was not to record the dispute. State was not to define the disputes. State was only an neutral arbiter at that time. It was only the Sabha which would bring the dispute. And secondly, as Madam has correctly pointed out, there was no professional intermediaries at that time. There was no institution of advocacy. Only there was a Sabha, and the members of Sabha were well versed in secular texts as well as religious texts, which were governing the each and every aspect of the time. There were professional guild members also were there, and their integrity was supposed to be impeccable. And you would be surprised if there is any procedural flaw, or eventually the judgment is proven wrong or faulty at some point, the Sabha would be penalized. That was the level of judicial accountability at that time. And secondly, what we have found in the study, that you see, dispute has arisen due to multiple versions of a fact. So there is certainly some untruthfulness. That is why dispute has arisen. So pleading is the most important aspect. So when there are no professional intermediaries, then the concerned party would tell about the accusation or complaint regarding Sabha. So there is a very little room for any omission in the pleading or any inconsistency. So when this pleading is completed without fault from both the sides, then only evidence has to be taken and the answer would be given. But now we see there is a great niceties of procedure. So the time in which Samriti was prevalent, the time in which we are in the modern law times is certainly different. Another important point which is described in Samriti is that certain disputes cannot be brought before the Sabha. For example, marital disputes. Marital disputes, Sabha has no jurisdiction to decide. Concerned societal guild would decide. The dispute between a teacher and disciple would not come. So educational disputes would not come. Master and servant dispute would not come. So the category of disputes was in a way limited. And with this modernity, the disputes have also arisen multifold. Now the state is one of the pillar in adjudication. So the very structure of society is different, but what is similar is the psyche of people, the cultural psyche, the historical psyche of people, the DNA of our people, the cultural quest for justice, social quest of justice is running in the blood. So in order to understand
I think due to some technical error, Ramakant Sharma sir got disconnected, maybe because of a technical glitch, I think.
You can call, sir.
So it is a time to call our president of today's function, is none other than Professor Dr. T.R. Subramanya sir, Dean CMR University School of Legal Studies and former Vice Chancellor of Karnataka State Law University, Hubli. And it's really a privilege and honor to listen to you, sir. Now I request Professor Dr. Subramanya Tudiyadika sir to deliver a presidential address, sir.
Yeah, very good evening to all of you present here. Madam Srimati Sneha Bipin Sapre, Dr. Ramakant
Sir,
Sharma.
please open your video, sir. Subramania, sir, please.
Yeah. Dr. Ramakant Sharma, Mahadevaya Ravdahalli, Professor Raj Kumakaddi, and Professor Girish, and all the other friends who are here to listen to this lecture. Now, I just intend to bring in of what Madam has said. See, the issue relating to the procedural and substantive law has been explained in such a marvelous way today, because it is the rarest of the rare opportunity to listen to this. Because if you just go through the textbooks in Hindu law, all the books on Hindu law are totally silent on this matter. And extensive material that is being collected and collated and presented is really praiseworthy of the madam, and that will be of immense help for the institution, especially founded by the great soul or Ram Joyce. So then the other thing I just wanted to speak to you happened to be the concept of speedy justice then and the concept of speedy justice now. I just intend to give an illustration which was said by one of the ministers yesterday. Every year, this is in support of Madam's speech, every year we add 2 crores of population in this country. So when the population of this country increases by 2 crores every year, the number of litigations which go before the court of law naturally gets increased. And any government or any judiciary member will be finding it very difficult to find a solution to this. When you try to devise a solution, the population goes up and the increase naturally gets increased further. Now, for instance, the Supreme Court earlier in the 19 in the first decade of this century has appointed the national grid. And having founded the national grid, it was in a position to find out how many cases are there in each of the courts. And everyone, every student of law, every researcher in law, every professor in law was able to know the pending cases relating to litigation before the court of law. We would come to know in Karnataka itself, it will be about 14 lakh cases. Maharashtra, it is about 20. West Bengal, it is about 12. So in these circumstances, what measures are to be adopted? Now, Madam explained the measures which were adopted in ancient India. And these measures, remember, were suited to the time. And since we live in the age of technology, what measures are adopted? Which part she has not spoken. Now, I just intend to just brief you one or two things or the steps which are being taken by the Supreme Court of India. One is the establishment of the national grid. Now, the second one important thing is translation of all the judgments in the state vernacular languages. Now, it is done in such a swift way. In the year 2023 itself, as many as 36,000 cases, important cases were translated and were made available to the lawyers, the public, the judges, and everyone. And this is of immense use for everybody. Now, in addition to that, the use of AI, artificial intelligence. Now, because I have been in touch yesterday with one of the sitting judges who is a district judge, I was just asking him, chatting him, whether the AI has helped you. And if it has helped, in what manner? Did it reduce the burden of the court? If it has reduced the burden of court, in what manner? So he was just telling after the introduction, the introduction of the AI-driven platform, remember, the judges in the court of law, the moment they go, they will be in a position to come to know on each day the complex cases that are listed for the day. And the second one is they will be in a position to find out the simplest cases that are found for the day. So remember, for the simple cases, they will be in a position to finish it off in an hour. And there is no need to adjourn, because the same analogy, the same principle, and the same precedent that is being applied is given to them. For the complex cases, naturally, when you use the AI, it supplies the precedent. And it not only supplies the precedent from India, it even provides you the precedent that is being decided in other courts abroad. So that naturally strengthens the grit of the concerned judge to finish it off at the earliest. Because otherwise he had to sit, he had to search, he had to find out the ratio decidendi. All these matters will have to come from the head. And here, remember, the AI is providing the assistance and helping the judge to do the needful. Now, the important thing is translating from languages, from all the languages. Now, all the judgments, important judgments are available even in Kannada, even Marathi, in other things. This actually helps a lawyer who is, remember, slightly weaker than others in English. Or you'll be able to know what exactly it is done. More than this, it helps the clients to know what exactly the judgments. It helps him to develop and know what could be the decision, because he will go through the precedent and will find out. Naturally, the translation of the language not only helps the court and helps the court, but more than that, it helps even a client who has gone before the court of law to fight a case on a particular point of law. Now then, the other point is in the translation which is being made. I just asked because while translating, there are a few words which cannot be translated at all in the local language. And the translation which will be given is meaningless, or the translation cannot be accepted by a few. So in such circumstances, he was telling, they have examined this part also. The Supreme Court examined, and having examined, they went to the extent of declaring that in 90% of the cases, there is accuracy in translation. So 90% of the cases, there is accuracy in translation because it is done by the AI. Then recently they have introduced a plan, especially in the 30,000 court. Now, this is a pilot study. Pilot study relating to what? This is relating to legal research analysis assistant. So it will be providing you the material, and having provided you the material, then it will get in touch with the stakeholders. Thereafter, you can prepare what the shape of things to come in the near future. So they try to examine from the thesis court itself, and then it will be implemented in pilot projects in the remaining courts in the state of India. Now, the other important thing that is being spoken happened to be digitization of documents. See, this was not found at all for the first time. The Supreme Court in the 1990s, when Chandrachud became the Chief Justice of India, this project was undertaken in a missionary zeal. And I have spent at about 7,210 crores only to digitize the entire records. So your record is safe, and your record is kept for posterity. The generation or the generations come after us also will be able to know the original record, what we call as the mother deed or some other deed, whatever we have in law. So this is how it has helped us. Now, the other point which I just wanted to speak is for the law students, there will be a good news. Now, for example, Indian knowledge system, we have been speaking for years, and a chair of this nature established at the behest of the great soul is in a position to serve and provide the material and bring people and listen to them and get it published at a later stage. But then more important of all, the UGC has taken up the task of introducing a new jurisprudence paper. Now, the new jurisprudence paper, which is going to be introduced by the UGC, are in circulation with some important people who are teaching the subject. Now, when I speak about this, remember they are going to give the Indian knowledge system. And when I speak about the Indian knowledge system, naturally, when we speak of your custom as source of law, then the other digest as a source of law, then we have principles of equity as a source of law, legislation as a source of law, and precedent as a source of law. They are including the most basic precious material from our historic times, from the time of the Shrutis, Smritis, the Veda. The Shrutis, the period of the Vedas, and then Smritis, we have a lot of people who have contributed. Then you have the period of commentaries and digests. A few of you may ask me, what is this and what do you mean by this? Now, for example, you have the concepts like Vyavahara, Achara, Vyavahara, and Prayaschita. Prayaschita is Vidhi. Now, these concepts, remember, were not constant even in ancient India, even in the period of BC. Achara, Vyavahara is always subject to change, because in the Shanti Parva, one of the statements go to the extent of pointing out a particular thing which is not usable, a particular practice which is obsolete, it should not be allowed to be practiced. It came from the mouth of Bhishma itself when he was on the bed of arrows. So that kind of thing, when it was said in the period of Mahabharata, remember, it is no wonder it has become part of law, and the law is changing from time to time. It changed then, it is changing now. Because you take it this way, there were instances, if you read to the Smriti of Narada, how the institution of marriage got changed, and how certain marriages were considered as void, and how these marriages are considered even now void. Because the same thread is continued from that period to this period. And where changes are required, for example, in those periods, some of them did not canvass for a property right for a woman. And immediately, as and when the constitution came in, we spoke about equal rights. And there was a lot of, remember, pressure not to bring in the Hindu law, provisions of the Hindu law of 1955 and those four legislation. But then the government mustered courage, and having mustered courage, brought the law. In the year 19, Hindu Marriages Act came in, and wherein, remember, the concept of divorce came in, and the grounds of divorce were increased, and there were special rights of divorce for a woman herself. These are, remember, from a rigid society, a static society, which was suited to the time, being applied even today, and applied even today by changing the certain things. So this is what, remember, the new dimension of law. In the ancient period, in addition to this, there are certain things which are to be accepted. That is also being spoken at length. The one important point is, for example, Dharma, Nyaya, Mimamsa, and Arthashastra. Dharma, Nyaya, Mimamsa, and Arthashastra, remember, is followed even today. You take the Western legal system. When we speak of Dharma, they speak of rights. And these rights are sacrosanct. And these rights which are sacrosanct are must be respected by anybody. And there is no provision for violation. Now, the concept of Nyaya. Nyaya means, remember, everything should be reasonable. And it cannot oppose public policy. And if it is opposed to public policy, it is not, cannot be accepted. See, that kind of system which was prevalent is being interpreted in the 21st century, even in the Universal Declaration of Human Rights, even in the covenants of human rights. So this is what we are bringing in. And when we speak of Dharma, Nyaya, Mimamsa, interpretation. Interpretation is the concept which I said, changing. What is absolute cannot be accepted. That is where change took place then, change taking place now. And that is where you compare with the Western philosophers, the authors, the schools of law, the theories of law, then the administration of justice, and the concepts in law. And we too had our concept in ancient India. And there is no time to speak about it. And these concepts, remember, changed from time to time. Many people who are not entitled to get a share at a later stage were brought in. Even now, we are bringing it. Even the other day, some people were brought in into the realm of this under Section 6 of the what we call the Succession Act. This is the way where the law is changing, and many things are there. And Madam has spoken really well, and it is a precious material of what she has said. Because even regarding the procedural law, I had not read anywhere. Only I heard now, and it is a wonderful contribution. There is. I thank all the organizers, Mahadevaya, and all the others. Once again, with best wishes to all of you. Thank you.
Thank you. Thank you very much, sir. It was really an intellectual feast to listen to you. And we always wish that we should listen to you more and more. And in your presidential address, you have enlightened us with regard to so many areas, and with a wonderful analysis of how when population increases, the cases is naturally bound to increase the disputes. And you have also thrown light upon how there is an establishment of national grade, as well as this translation of judgments into a vernacular language. And you have added value to this particular lecture through your presidential lecture, even by highlighting the concepts of Dharma, Nyaya, Mimamsa, Arthashastra, and many other observations. And it was really a wonderful presidential address like we have listened so far, sir. And with this, if Mahadevaya Kardalli sir permits, sir, can we go for one or two questions? ಅವಕಾಶ ಕೊಡ್ಬೋದಾ ಹೇಗೆ ನೀವು
ಫಸ್ಟ್ ವೋಟ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ಕೊಟ್ಟು ಟೈಮ್ ನೋಡೋಣ ಸರ್.
ಓಕೆ ಸರ್,
ಟೈಮ್ ಟು ಟೈಮ್ ಮುಗಿಸ್ಬಿಡೋಣ. ಆಮೇಲೆ ಇಫ್ ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ ಅವೈಲೇಬಲ್ ದೇ ಕ್ಯಾನ್ ಆಸ್ಕ್ ಕ್ವೆಶ್ಚನ್ಸ್.
ಓಕೆ ಓಕೆ ಸರ್.
ಟೈಮ್ ದೊಳಗೆ ವಿದಿನ್ ಟೈಮ್ ಒಳಗೆ ಮುಗಿಸ್ಬೇಕು. ಸೊ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮತ್ತು ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಆಫ್ ಕರ್ನಾಟಕ ಅಂಡ್ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಲಾ ಯೂನಿವರ್ಸಿಟಿ ಜಾಯಿಂಟ್ಲಿ ಆರ್ಗನೈಸ್ಡ್ ದೀಸ್ meaningful celebration of Justice Dr. Rama Joyce's birthday celebration. I thank today's speaker who is passionately talk about Dharma Shastra, everything, Srimati Sneha Bipin Sapre Madam. And I thank Professor Dr. T.R. Subramaniam. He is a wonderful lecture. And Dr. Ramakant Sharma, who is a judge in Family Court Samashtipura, and Madam who has welcomed Dr. Maheshwari Ramat, Amit Deshpande, Krishna Sharma, Professor Girish Kesi, and one and all who supported us. This is then we are a rare opportunity. We have heard two sides of coin, that modern jurisprudence and ancient jurisprudence in one platform. I think we want this one. This samvada should be extended to the people. They should, when there is a samvada take place, that new thing will arise, that research will goes on. So I thank both the resource persons there for a light speech. I thank the people, the vice chancellors of both universities, deans of universities, and especially participants, the allied participants, shall I call, uh, principals, deans, judges, everyone who is there. I thanks from Vignaneshwara Pratisthana, both Central University and KSLO. Sri Lakshminarayan sir, who is with us since beginning. When there was nothing, zero, he has supported us as a deputy commissioner of this area. So he was with us for 25 years. Wherever there, he supports us. Thank you, sir. Thank you.
Thank you. Thank you, Madhura.
One I want to share this one, the justice delivery system. When I read with A.R. Krishna Shastri, Bankim Chandra Chatterjee Pustaka, Bankim Chandra Chatterjee was also magistrate. He served for British for 33 years. When he come to case, one Brahmana, while going to another village, he stayed at night at one villager's house. When he was sleeping, one thief entered the house, but this Brahmana Haridas has seen that their thief. You want to catch him, but thief was strong than Bankim Chandra Haridas Brahmana. He catch him, and as if he was the thief and he is protecting, like that he does that. The case came before Bankim Chandra Chatterjee. After hearing that, there was he thought that there is something else. So he did that hearing will be tomorrow. He called his courtman, one man, and go to ask him, pretend some like that. Day after tomorrow, when court starts, Bankim Chandra said his office man has died. We have to bring his shava, that what we call body, to here. But he told that only Haridas and thief will go and come back. Both they gone and picked up that body. While coming, they are discussed that why you are catch me, unnecessary you are fielding problem, you could have avoided it, you can leave me, like that they talk. After coming here, the man, where there was no witness at that time, he told that it is the thief is the real thief, not the Haridas. Then Bankim Chatterjee has delivered. This is type of very recently this case happened. So I think it is share with the people who are there. Details can be heard from Bankim Chatterjee history. From these are the type things. Thank you, sir. Thank you, one and all. Vignaneshwara Pratisthana seeks your wholehearted cooperation in spreading Dr. M. Ramajoy's message that Yuganukula Dharma Shastra is to be prepared and research has to be done, workshop has to be done, and Bharata should be the leading force in jurisprudence for all the world. So thank you, one and all. Now I request resource persons stay back for if there any one or questions if they're from audience. Otherwise, we can conclude. Sir, over to Girish, sir.
Yes, sir. I also acknowledge the presence of Renuka Gubewad madam and Dr. Bhima Bai Mulge from Karnataka State Law University. So if anybody is willing to ask any questions, maximum 1 or 2 questions, like you can please ask, and president of today's function is there and the resource person is also there. If ಯಾರಾದ್ರೂ ಪ್ರಶ್ನೆ ಕೇಳೋಂತವ್ರಿದ್ರೆ ಕೇಳ್ಬೋದು, ಇಲ್ಲಾದ್ರೆ ಈ ಮೀಟಿಂಗ್ ನ ಎಂಡ್ ಮಾಡ್ತೇವೆ. So if there is anybody who is willing.
Basaraj Kukaddi sir is also there, I think.
Yes, sir. Basaraj Kukaddi sir ಇದ್ದಾರೆ. ಅವರು ಆಗ್ಲೇ ಲಾಗಿನ್ ಆದ ತಕ್ಷಣ
ಬೇರೆ ಕಾಲೇಜ್ ಪ್ರಿನ್ಸಿಪಾಲ್ಸ್ ಇದ್ದಾರೆ ಬೇರೆ. That's all.
ಹೌದು ಸರ್.
Anyone, those who are interested, they can come with questions.
And we cannot take the name of every participant. So we thank each and everyone who have joined this particular online lecture series. ಬಹುಶಃ ಯಾರು ಪ್ರಶ್ನೆ ಕೇಳೋರು ಇಲ್ಲ ಅಂತ ಅನ್ನಿಸ್ತದೆ ಸರ್. ಯಾರಾದ್ರೂ ಇದ್ರೆ ದಯವಿಟ್ಟು ಪ್ರಶ್ನೆ ಕೇಳೋದಿದ್ದಲ್ಲಿ ನಮ್ಮ ಸುಬ್ರಹ್ಮಣ್ಯ ಸರ್ ಇದ್ದಾರೆ, ಇನ್ನು ಲೈನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ. ಹೇಳಿದ್ರೆ ಅವರ ಆ ಕಾತುರತೆ, ಅವರ ಆ ಮಗ್ನತೆ, ಯಾರಾದ್ರೂ ಕೇಳಿದ್ರೆ ಉತ್ತರಿಸ್ಲಿಕ್ಕೆ ನಾನ್ ರೆಡಿ ಇದ್ದೇನೆ ಅನ್ನುವಂತ ಆ ಒಂದು ಗೆಸ್ಚರ್ ಸರ್ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. ದಯವಿಟ್ಟು ಏನಾದ್ರು ಇದ್ರೆ ಕೇಳ್ಬೇಕಾಗಿ. ಈ ವೋಟ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ನಡೆಸ್ಕೊಟ್ಟಂತ ಮಹಾದೇವಯ್ಯ ಕರಡಳ್ಳಿ ಸರ್ ಅವರಿಗೂ ಹೃದಯಪೂರ್ವಕ ಧನ್ಯವಾದಗಳು ಸರ್. ಸರ್ ಯಾರು ಪ್ರಶ್ನೆ ಕೇಳೋರಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಶಾಂತಿ ಮಂತ್ರದೊಂದಿಗೆ ಮುಗಿಸೋಣ ಸರ್. ಸರ್ವೇ
Yes.
ಭವಂತು ಸುಖಿನಃ ಸರ್ವೇ ಸಂತು ನಿರಾಮಯ ಸರ್ವೇ ಭದ್ರಾಣಿ ಪಶ್ಯಂತು ಮಾ ಕಶ್ಚಿತ್ ದುಃಖ ಭಾಗ್ ಭವೇತ್. ಓಂ ಶಾಂತಿ ಶಾಂತಿ ಶಾಂತಿ. ಮತ್ತೆ 13ನೇ ತಾರೀಕು ಮತ್ತೊಬ್ಬ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳ ಜೊತೆ ವಿಚಾರವನ್ನ ಕೇಳಲಿಕ್ಕೆ ಎಲ್ಲ ಪಂಡಿತೋತ್ತಮರಿಗೆ ನಾನು ವಿನಂತಿಸಿಕೊಳ್ತೇನೆ. ಮತ್ತೊಮ್ಮೆ ಮಗದೊಮ್ಮೆ ವಿನಂತಿಸಿಕೊಳ್ತೇನೆ, ದಯವಿಟ್ಟು ನಮ್ಮ ವೆಬ್ಸೈಟ್ಗೆ ವಿಸಿಟ್ ಮಾಡಿ ಮತ್ತು ಮರ್ತೂರಿಗೆ ಬಂದು ನಿಮ್ಮ ವಿದ್ಯಾರ್ಥಿಗಳೊಂದಿಗೆ ನಿಮ್ಮ ಸಹಕಾರಿಗಳಿಗೆ ಬಂದು ಇಲ್ಲಿ ನೋಡ್ಬೇಕು. ಉದ್ಘಾಟನೆ ಸಂದರ್ಭದಲ್ಲಿ ನ್ಯಾಯಮೂರ್ತಿ ಜಸ್ಟಿಸ್ ಲಹಾವಟಿ ಅವರು ಹೇಳಿದ್ದಾರೆ, ಉಳಿದವರಿಗೆಲ್ಲ ಕಾಶಿಯಾಗೆ ಮರ್ತೂರು ಲಾ ಓದೋರಿಗೆಲ್ಲ ಲಾ ಪುಸ್ತಕ ಮುಟ್ಟಿದವ್ರಿಗೂ ಕೂಡ ಕಾಶಿ. ಪ್ರತಿಯೊಬ್ಬರು ಬ್ರೆಡ್ ಅಂಡ್ ಬೆಟರ್ ಕೊಟ್ಟಂತ ವಿಜ್ಞಾನೇಶ್ವರನ ಜಾಗಕ್ಕೆ ಬಂದು ನಮ್ಮ ಕೃತಜ್ಞತೆಯನ್ನ ತಲುಪಿಸ್ಬೇಕು ಅನ್ನೋ ಮಾತನ್ನ ಹೇಳಿದರೆ ಅದನ್ನ ನಾನು ಪುನರುಚ್ಛಿಸ್ತೇನೆ. ಧನ್ಯವಾದಗಳು, ಅವರಿಗೂ ಧನ್ಯವಾದಗಳು. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ಸುಬ್ರಹ್ಮಣ್ಯ ಸರ್ ಅವರು ಥ್ಯಾಂಕ್ ಯು. ಸ್ನೇಹ ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು.
Thank you, Rajeshwari madam.
Thank you so much, sir, for giving opportunity. Thank you very much.
Thank you, Sneha. Thank you, one and all. With this, we will put an end to today's
We can
session.
conclude now.
Yeah. So, Tapesh sir, we can wind up the session.
Okay, sir. Can I stop the recording?
Yes,
you can. Stop the recording and,
I congratulate, thanks Tapesh sir also to support technically. Thank you.
Okay, thank you, sir. Thank you.
Yeah,
Tapesh
sir. Please
Megawal
end
is
the
a
meeting,
research
sir.
scholar. Please conclude.
Thank you, sir. Thank you, sir.
End the meeting, sir.